I've had an opportunity to reconsider the defense's additional pleadings that were filed in this particular case on motion to reconsider bond. That was filed on behalf of Mr. Williams. I have considered those arguments under the new indictment of 22 SC 13572, even though they were filed under indictment 22 SC 182273. And I've considered the proffers made by the state. I've considered the arguments of the defense. At this point in time, though, Mr. Adams and Mr. Steele, I am still not convinced that that what you've argued, or what you've continued, or what you've argued anew and taking into account what I have heard already, I still believe that the court, it is the court's decision that the four factors under consideration, that I'm going to deny bond at this point in time. It is not lost on me that your client's in custody. Not lost on me your client enjoys a presumption of innocence. I respect all of you as seasoned advocates, and I understand fully that there are differences in bond and differences in what may be pled at trial. And I understand that you all as defendants don't have any responsibility at all to present anything, that the government has the responsibility to present and prove everything that's alleged in the indictment and the elements therein to a satisfaction of beyond a reasonable doubt. So that will be decided later, but at this point in time, under Title 17 and under the case law that's been argued thus far, I am not going to grant bond at this point in time. Bond will stand denied. All right, is there anything else I need to kind of go through with you all at this point in time? Mr. Adams or Mr. Steele, we have proffers. The remaining proffers, I will attempt to try and get those folks here for the 8th of September, who are otherwise unrepresented or maybe in the Department of Corrections. Anything else? And I understand you all have some motions you're about to file. If you should, for whatever you file, please send courtesy copies to myself and in particular Mr. Kearns and Mr. Chamberlain, so that because we're not an e-file party, the court is not an e-file party, and that's the only way we'll get those. And upon getting those, I will figure out a date and schedule you all for any motions that may need to be heard or issues that I need to take up, okay? Yes, sir. All right.